okay. Nothing much. How about you?
I'm doing good. I just got out of class and it really embarrassing happened.
What happened?
Oh, I can't. I don't really know.
You brought it up, so just tell me.
I don't really want to share. It's kind of embarrassing, and I gotta run.
Okay, I don't even know you. See, that right there, that actually really bugs me. Don't bring it up if you're not going to tell me. Ambiguity and vagueness. Not fun. Ambiguity also takes a role in international law in the sense that it is very, very much detrimental to international law to have ambiguity. There are ways to deal with this, most commonly interpretation. For example, Part 2 of Article 17. The consent of states to be bound by a treaty which permits a choice between provisions is in effect only if it's made clear to which provisions the consent relates. We have to be on the same page. If I do not know what's going on, you're not on the same page. This is not how things should work. When a treaty is found to be vague, you can go back to the Treaty on Treaties. It tells us to interpret. Article 31 of the Vienna Convention outlines the general rule of interpretation, which requires a treaty be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, in their context and in the light of object and its purpose. So, you're going to stick with what makes sense. It's really not that complicated in a sense when you're looking at this. When it comes to these treaties, you are not going to interpret it outside of, with your best intentions at least, the way it was meant. If we're going to relate this to individuals, if somebody brought something up and they were really, really vague, well, hypothetically, if a hyperbole came in there at some point, your friend randomly mentioned that they could have eaten a horse. Yeah, they weren't ever going to eat a horse. That is not what they meant. Your goal is to stick with what was meant. Nothing in international law is any more ambiguous in the future. Same with individuals. Nobody knows the future. So, when you're dealing with really, really important issues where whatever decisions and policies you're making are going to have very serious, long-lasting effects, you're going to go with the precautionary principle. You're going to do your absolute best to ensure that the decisions you're making will have the least negative repercussions in the future. Different places where this comes into international law is the advisory opinion of 1996 on the illegality of nuclear weapons. Also, environmental conventions like the Stockholm and Rio declarations. Finally, the UN Declaration of Human Rights is another big one. All of these issues are so important and so complex and so far-reaching in their implications. While these were drawn out, there must have been the utmost attention paid into being precautious and basically doing the utmost possible to mitigate any possible repercussions. But at the end of the day, you're not going to be able to mitigate everything, but you do your best. Another way of tackling uncertainty is taking omissions as reasonable cause for making inferences that whatever information is being intentionally withheld is very negative in nature. Basically, what did you have to hide? A very serious case in which this was brought up was in the genocide case between Bosnia and Serbia. The courts made the inference based on the large portions of evidence that were redacted by the respondents, whose argument was it was necessary for national security. Basically, because they had redacted so much information and were withholding evidence and facts necessary to adjudicate on this case, it was assumed that everything that was withheld was of an extremely negative nature and was adjudicated on that assumption. In conclusion, ambiguity and vagueness, and most especially intentional omission, are all perceived extremely unfavorably within international law. Also, usually dealt with and perceived unfavorably within individuals, within groups, within other elements of society. People like to know what's going on. People need clear communication in order to progress, in order to get anything done, really. Interpretation is the most common tool used, both between people as well as within international law, while in certain circumstances, willful omission may be interpreted by the discretion of the parties involved.